Retaliation claims are claims brought by an individual employee claiming that he or she was subject to some adverse employment action because they had engaged in some protected conduct. For example, an employee who brings a sexual harassment claim continues to be employed by the company and then believes that she is being mistreated because she had filed a claim against the company. Retaliation claims are now the #1 type of claim filed with the EEOC, that's the Equal Employment Opportunity Commission. We've seen this sharp spike in retaliation claims because retaliation claimants tend to succeed more than other types of discrimination claimants. Not only are retaliation claimants succeeding more often, but they're also receiving more significant damage awards, usually punitive damage awards. And that's because juries tend to punish employers that don't protect employees who engage in protected conduct. To respond to this growing incidence of retaliation claims, employers should have anti-retaliation policies in place. Employers should also be proactive in dealing with potential retaliation situations. There's a currently employed worker who has made an internal complaint, for example, sexual harassment. The employer shouldn't sit back, ignore that employee. Rather, the employer should be proactive, should counsel that employee concerning his or her rights under their anti-retaliation policy, assure the employee that the employee will not be subject to any retaliation, and also manage the situation more broadly, perhaps changing the reporting relationship, changing where the two employees involved work. Lastly, employers should review all employment actions that may affect someone who has brought an internal complaint or otherwise might be a potential retaliation claimant. Retaliation claims are very dangerous, but they can be managed. Taking a cool-headed approach to a potential retaliation claimant can greatly reduce the risk.